Mr Chair.
Mr Chairman.
Mr Chair,
Mr Main.
I move that the question be now put.
I'll take one more call from Grant Robertson.
Thank you very much, Mr Chair. I want to go back to Clause 8, but before I do go back to that, it is part of Clause 8 one to refer to help Mr Quinn out, and that is Clause 8.3. When determining whether an applicant has sufficient means to enable him or her to obtain legal assistance, the Commissioner must, except as provided under Section 9.1, have regard to the applicant's income and disposable capital as set out in Schedule 1. We go to Schedule 1, and Mr Nash did an excellent job earlier on of working through some of the issues within Schedule 1, for instance, around the resources of a spouse or partner. And we have come to Clause 5 of Schedule 1, which is around resources relating to Māori land. In this clause, it goes through and describes the applicant as a person applying for legal aid. The income of the and assessing what resources relating to Māori land will be brought into account. The income of the applicant includes any rent derived from Māori land or interest in Māori land. Now, as Mr Mallard pointed out earlier on, it is perhaps fair enough to look at rent derived from Māori land as being part of income derived from the rent as being something legitimate to be tested against as to whether you have the insufficient means or you meet the insufficient means test.
Put in the trust.
That's right.
Doesn't count.
Yeah.
Māori land does.
That's right. But then we go on to subclause 3, and this is the point. The disposable capital of the applicant includes Māori land and any interest in Māori land unless it's the subject of a Waitangi tribunal proceedings. That's the point. Now, Mr Quinn tells us, well, it's not disposable, so therefore it's not disposable. Well, why is it then in the schedule being described as disposable capital if it isn't disposable capital? So that's the problem that's been raised on this side of the House. Mr Quinn's gone very quiet now, but the fact of the matter is this clause actually needs some explanation, because otherwise we're left in the situation of something that Mr Quinn himself has told us is not disposable being considered under disposable capital. So that's part of Schedule 4. I just wanted to help Mr Quinn with that explanation so that he understands that's the issue that's being raised by members of this side of the House. But I want to go back, Mr Chair, and it's the nature of these kinds of discussions, to something that Kevin Haigh said, and he's actually he raised an issue with us earlier on around the question of what will be considered by the Commissioner when they are, under Section 8.2c, when they are obliged to consider what are the interests of justice, whether the interests of justice merit someone getting legal aid. And Kevin Haigh raised some very interesting points, I think, as he worked through Clause 8, Subclause 2, around some of the issues that are supposedly part of the question of whether or not justice requires the person to receive legal aid. Now, earlier on in my early interventions, I mentioned that this was obviously a balance within legal aid. The most important principle is the fact that people with insufficient means have access to justice, and I discussed that in my first contribution. But then, obviously, there is a balance to how we define that, how we make sure that it remains within a manageable amount of resource for the taxpayer and is given to those who genuinely do need it. And obviously I talked about the tests around withdrawal, but I think what Mr Haigh raises is very significant. That if, for instance, subclause 2A1, whether the applicant has any previous conviction, what is the relationship of that to whether the interests of justice are being served? I think that is a very legitimate question. In most cases, jury trials, for instance, juries are not made aware of previous convictions. So why are we now using that as a determinant here of the question of whether one receives legal aid? So I think they are important questions, and it would have been good to hear from the Minister about how these have come about. They may well have come over from previous legislation, and I'm not necessarily arguing that this has been introduced brand new by this government, but it does raise that important balancing question. Access to justice for those with insufficient means versus the ability of the taxpayer to be able to provide the resources that are needed. And obviously there do need to be tests, but these tests under 8.2 I think do require a bit more analysis and a bit more explanation because they do start providing limits. In relation to that, not only do we have in this bill the situation of the ability for legal aid to be withdrawn, which I mentioned in an earlier contribution, counterfeit provisions, clause 51, subpart 7, that actually allow applicants to apply to the Legal Services Commissioner for review. That is an important part of the process. Review of these decisions and making sure that we do have that balance.
Mr. Chairman,
The Honourable Chris Finlinson.